Okay, Bob, I think we're ready to go to session 4 here.
All right, good afternoon, everyone, and welcome back to our fourth session. Bob Christoffel and John Garrison from EY. Just another reminder, this is being recorded as a separate segment and will be available for your viewing. Please submit any questions that you have through the question box. I'll be monitoring that, answering questions, as well as raising some questions up to John Garrison. Estate planning is certainly important, especially as our parents get older. It is important to have things in place. Everybody has an estate. It's not just for rich people. I think it's also things like how you title assets, powers of attorney, healthcare proxies, and things like that. So I'll be quiet for a moment and turn it over to John Garrison. John, thank you. I appreciate it's been just a great EY financial planning day for the Baltimore-Washington annual conference. We appreciate you being part of it, John.
Okay, many thanks, Bob. Appreciate it. Really a pleasure to be with the group once again. Look forward, hopefully in the future, to coming back down to Fulton and being live. But as Bob said, estate planning is really key. It's one of those things that's easy to put off. One of the things that I want to make very clear during the session today, there are a lot of misconceptions about estate planning. Gee, everything is controlled by my will. That is not the case. So if you have a will and a will alone, chances are there's some significant gaps in your estate plan. So some of these misconceptions that are out there, hopefully I'll be able to clarify them and put you on a strong path to getting this done. I'll lead by saying the first thing I would do in putting together an estate plan is call the Navigate Planner line, and here's why. This will really set the framework for our discussion. They can take you through what I call structuring the meeting with your attorney. And you always want to use a licensed attorney in the state in which you reside. Because if you're putting together a plan today in the state of Maryland, let's say, and you move to Florida in retirement, one of the first things you'll want to do when you move to Florida is update your plan. You don't have to recreate the whole thing. But chances are that some of the things we're going to talk about, specifically any state taxes or taxes that might be due, are certainly going to be different. And some of the provisions that you can take advantage of to mitigate those taxes, or in some cases eliminate them, are likely going to differ from the state of Maryland. So estate planning is highly driven by the state that you live in. And we have 50 states. And from what I can gather, I'm no expert on certainly all the states, but they're different in significant ways in virtually every state. So I can't make any sweeping generalizations. Guess what? If you do this, you're going to be fine in most of the states. You'll never hear me say that. One thing I can say that I think is helpful, and that is from a federal standpoint, at least with today's legislation, which I think has a couple of years until it sunsets, the likelihood of you owing a federal estate tax is extremely low. And hopefully the provisions that are current today are extended when this legislation sunsets in 2024, but more to come on that. So the key here is let the folks on the Navigate Planner line take you through that, I'm going to call it structuring the meeting with your licensed attorney. And what do I mean by that? What kind of information should you bring to the attorney's office? What kinds of questions should you be asking? What can you expect as a result of the meeting? What does a finished estate plan look like? I mean, these are fundamental things that if you feel good about these things going into the meeting, you're going to feel more in control and better about the outcome. Okay, I went in expecting this. I came out with what I expected. I feel good about the process rather than, gee, we really don't know what to expect. And I wonder if all the bases were covered. And gee, might have I overlooked or forgotten something? You don't want that hanging over your head. So the folks on the Navigate Planner line can help you plan your meeting, which is really key. So with that, let's jump in, see what we got here, some good information. Once again, Wespath is the source for Wespath benefit-related questions. Anything financial, as I've mentioned throughout the day, is fair game for EY. We cover the whole financial landscape, so take advantage of that. You have unlimited access at no cost to you. There's no sales pressure because we don't sell any products. The digital website, very robust resource. We'll see that again with this presentation, and all that's available on your phone as well. So you're very well supported. So you definitely want to take advantage of those resources. And like in the previous sessions, you're going to want to jot down some action plans because this is something, even if you have an estate plan, and actually Bob referenced this and he's right. He took the time during the pandemic to update it. Things can change. And before you know it, and I'm guilty of this, I think it was like 20 years before I updated mine. And then got remarried, lost a spouse in 2016, married in 2018. So that's a whole new world. So basically had to redo the whole plan. And a lot of things changed. Let me just tell a quick story here because I think this kind of underscores in a big way how some things can change. My initial retirement 10 plus years ago, I named my spouse at the time as beneficiary. Now, what's true with the Wespath plans and virtually most plans out there, I'm talking about pension plans specifically now. When you name a beneficiary, that beneficiary cannot be changed. So what happens? My spouse dies in 2016. The survivor benefit for my pension cannot be assigned to my new spouse. So what does that mean? It means in my case, I had a 75% survivor benefit. That is out the window and gone, okay? Same is true with healthcare, okay? You name, you're naming somebody at retirement, for healthcare. You generally cannot, change that in the future and have, subsidized coverage. So these are things you really got to, keep in mind. But back to the pension thing, what does this mean? Well, this is a huge change in my retirement plan because before 75% of my pension coming into my surviving spouse, you can nip and tuck a little bit and make that work. Zero is a totally different story. So that's just one example of what can happen during the course of a retirement that can really upend things. And so you want to have a little wiggle room. You want to be able to, plan for the unexpected. Obviously, you can't plan for everything, but having a little wiggle room is really key. So when you hear about, naming a beneficiary, this is a critical decision because that's what they call irrevocable. Cannot be changed, after the fact. So underscores some of the importance of these decisions that you're going to be making and what happens if unplanned things occur. So personal action plan, once again, jot these things down. I'll give you some at the end. Now, what about estate planning? And Bob gave away the answer to this, and as usual, he's right. Estate plan is only for the wealthy. No way. Everyone's got an estate. Everyone needs one, even the 22-year-old coming out of school. Estate planning is only for people who are old. Well, unfortunately, people who aren't so old die. Joint ownership makes estate planning unimportant. Absolutely false. This is one of those things, if I have a will, if I have joint ownership in my home, I don't need anything else. All this stuff is taken care of. Well, as you'll see, that's not true. There's a lot of misconceptions out there. Spouses automatically inherit everything. Absolutely not true. You're going to be surprised to learn. And I'll just let the cat out of the bag now. Your life insurance policy. You might think, oh, that's like my pension. That's like my UMPIP, my savings, my IRA, retirement asset. Federal law says if I'm married, my spouse is the automatic beneficiary. And that's true for those plans. It is not true for life insurance. So the person you've named on that beneficiary designation form, remember that form you signed decades ago when you took out a life insurance policy with a company on your own on the outside, life insurance that you have with Wespath. Wow. Okay. You've got to keep that thing current. And I used to work. I spent 30 years at Colgate-Palmolive, the last 10 of which were running benefits administration. We get calls all the time from people. Oh, I want to claim my life insurance benefit. My spouse, my husband, my wife passed away, and I know there was a life insurance policy, and I want to claim the benefit. And we would look up in the file and find out that it was some old girlfriend or old boyfriend. It was never changed after the individual got married. And guess what? The old boyfriend or girlfriend is the one who got the benefit. So there are a lot of misconceptions out there. So my goal, erase them. So what can estate planning do for you? I don't know about you, but I feel pretty confident about this, that you share the same belief I did. We've worked hard to accumulate our stuff. We want to be sure that our property is dispersed upon our death according to our wishes, not somebody else's. Now, here's the problem. If you have a will that's unenforceable, I'll say this several times because it's so important. You heard me say licensed attorney to prepare your estate plan. There's no substitute for this. I'm just going to be really stubborn and obstinate about this. Oh, but John, I found this thing online, and for $29.95, they gave me all the forms. I can fill this out, and I'm all set now. Well, I hope you are, but chances are you may not be. Why? Are those documents legally enforceable in the state in which you reside? If at your death, the local probate judge in the county courthouse determines, for whatever reason, that one or more documents are not enforceable, guess what? The probate judge and his or her staff, they're the ones that make the decision about some of your property and how it gets distributed. I don't know about you, but I don't want somebody in the county courthouse determining where my stuff goes. I want to determine where it goes. So more to come on that specifics. But again, that's what we mean by helps to distribute property according to your wishes. You have to have a robust and complete, you'll see there's 5 elements to an estate plan. You got to have them all. Taking care of survivors' needs, key, medical treatment. You heard Bob talk about healthcare proxy, things like living will, general durable power of attorney to manage your finances. There are many assets, or many aspects, I should say, many elements to your estate plan. And minimizing taxes, particularly on the state level. I referenced that earlier. So what is an estate? Well, it's basically everything that you own. What's confusing to a lot of people is, and I have a slide coming up that I think really clarifies this, what happens to the specific elements or pieces of my estate when I die? That's what generates all the confusion. But good news, there's a slide in here that clarifies that. But all these things, and a lot more, are elements of your estate. So everyone's got an estate. It's just what's in it and how much is in it. So what else do we want to do, have an estate plan do for us? Specify wishes for medical treatment. And what does this mean in plain English? It means if we suffer a stroke, for example, if I were to suffer a stroke and I am unable to make medical decisions, I can't communicate, I can't make decisions. Somebody is legally named and able to authorize appropriate medical treatment on my behalf. This is a really important element of your estate plan. And believe me, I've seen this. I'm pretty active in my church. And unfortunately, there are people that have had gaps in their estate plans and a lot of family feuds over, oh my gosh, dad wouldn't want to be put on life support. And one of the other siblings, well, how can you even think about unplugging dad? I mean, this stuff really gets complicated, highly charged during moments of stress. And in the end, whose decisions are these? They're yours. So it's your, I think, responsibility, obligation, those are strong words, but I believe them, to be clear about this in the form of an estate plan. And that way there's no confusion. This is what dad wanted. He put it in the plan, and you may disagree with it, but that's his wishes, and he made them clear in a legally enforceable fashion. That's really the bottom line here. what we're looking at. So I made a comment about a will not being the only element of an estate plan. It does make your wishes legal, helps clarify certain things during the what we call probate process, when the actual will and other elements of the estate plan are aired and executed, but it's not the only instrument in the toolbox there. So it basically controls personal property. We're going to see this on a slide in a couple of minutes. It also names guardians for minor children or disabled adults, should that person need a guardian, and very importantly, appoints an executor. Now, I'm sure many of you have either done this firsthand or have assisted parishioners in your congregations with executing a will and an estate plan. It's a time-consuming, difficult process. It's not a 10-minute job. And typically, as an executor, you're kind of a hub of the wheel. You are taking the material to the local courthouse. You are preparing or arranging for the preparation of tax returns, paying off debts. This is not a light responsibility. So when you appoint and name an executor, my message here is you want to name someone that is willing to do it, not just put it in the will and have that person notified. Oh my gosh, I had no idea I was John's executor. I can't believe he named me as his executor. You want to have a conversation with this individual and actually share the details with them so that the context of your will, your decisions, things that you have specified are carried out in a way consistent with your wishes. So the role of executor is really important. So what's the message here? Have a clear conversation with your named executor. Make sure he or she is willing and able to do this, and consider having a default executor. So if the executor is ill or not living at the time that you die, there's an alternate identified, which is key. This is probably my favorite slide in the deck because it clarifies for me really clearly what are the different elements in my estate and what drives the distribution of these elements of property, if you will, in my estate. Now, I made a reference, if we look at the left side of this, trusts, retirement plans I referenced earlier. Pardon me, things like your 403B, your pension plans, individual retirement plans, things that fall into what I'll call the retirement plan bucket, okay? They are governed by not only a beneficiary designation form, but also federal law that says if you're married at the time of death, your spouse, absent some waiver that is legally enforceable, is the beneficiary, okay? So that's why some people think this is not a reason to not have all that's in your estate plan clearly spelled out. Oh, it's going to be my spouse anyway. I don't have to worry about this, next. Bad idea. You want to have all this in writing, named, legally enforceable, etc. But I called out life insurance. Life insurance is different. Life insurance is guided by the beneficiary designation form. Nobody cares about your marital status when it comes to life insurance. Married, divorced, separated, thinking about getting divorced, want to be divorced, should have been divorced. Nobody cares. It's all about who's on that beneficiary designation form. So this goes for any and all life insurance, whether you got it from a company, whether you got it on your own, doesn't matter how old it is. You want to dust off one or more beneficiary designation forms. Each individual policy is governed by an individual beneficiary designation form. Make sure they're all current. And I'll just say this, everyone participating knows who the right person for their life insurance benefit is. I'm just going to leave it at that. So really key. So in a way, that's a little bit confusing. Beneficiary designation, yes, applies to all of those, but the marital piece, the federal law piece, only applies to the retirement plan. So that's really important. Now, what about joint tenancy? And the acronym in the middle slide there means joint tenancy with right of survivorship. This is a very common form of home ownership. And from a state tax planning standpoint, I'll say in most states, because I frankly don't know if it makes sense in all 50, is the right way to go. But this is the 10th reason that you're using a licensed attorney in the state in which you reside. He or she's going to know from an estate planning standpoint, from a standpoint of minimizing any state taxes that might be due on the first or second death in state X. Joint tenancy is the way to go, or some other form of ownership. There's no way lay people like you and I are going to know the answer to these things. I am not a trained estate planning attorney, so I, like you, am going to a licensed attorney, someone that does this 24/7, is up to date on all this, and knows New Jersey law inside and out. Because in New Jersey, we're really lucky. We have two forms, two ways that they can tax us after we die, not just one. So we really have to be on our toes here. These federal maximums that you're going to see shortly of $12 million do not apply at the state level. So assets held in joint name, joint tenancy with right of survivorship, typically that's homes. That is probably the biggest category of assets titled in that fashion. Now, you heard me reference earlier the will. You see this in the third column on the right, is for the most part governing what I refer to as personal property, assets owned outright. Art collections, furniture, coin collections, personal property, okay? So the will governs that. So right away you see here, wow, the will doesn't govern necessarily the other assets in the other two columns. Now, what happens is, unfortunately, a lot of people die without a will. So what happens is the local probate court, based on state law, will make decisions about the distribution of property. So you hear all the time, and believe it or not, it's amazing how common it is. I mean, celebrities dying without a will. It's like, really? Leaving significant assets in the hands of the local county court to distribute. I mean, wow. So you absolutely want to have an enforceable document, because once again, you may have a document, but if it's not enforceable, then it's not worth the paper it's printed on. So I think this chart is really helpful. What drives the distribution of assets? Beneficiary designation forms, forms of ownership, and the will, depending on the type of property in your estate. That's really the key message here. So what is probate? I've made a reference to this. Basically, the first step after you die is any and all legal documents go to the local courthouse. There's typically a probate judge or judges that are focused and trained on managing the distribution and disposition of estates. So that process is known as probate. I know my father-in-law died a couple of years ago. My wife, being an only child, was the executor and basically handled the whole thing. It's a significant amount of work. He lived in Pennsylvania. She wrote a very significant check to the state of Pennsylvania, even though he had a very complete will. But Pennsylvania, they're pretty good at taxing assets after you die. And the amount of work, a few meetings with the attorney's fees, and the time. It generally takes a year to 2 years in most cases. So it's not a 2-week thing and you're done. So the first step is everything goes to the county courthouse and it is deemed enforceable. So court approves your executor and names a representative, supervises distribution of assets and payment of debts. That assumes that the documents that were presented are legally enforceable in the state. That's the key. So again, I'm making this point. Don't even think of using online resources and doing this on your own. It's a significant risk that I myself would never take. So there's some advantages and disadvantages to probate. Number one, trained people are determining the validity, because it is not at all uncommon for wills to be challenged. I mean, even the most loving of families, sprinkle a little money over them and it becomes a war zone. So it's up to the court to determine, oh, this is the enforceable will. But, oh, I have a copy of the will. Yes, you do. But that was superseded by another will. So the court sorts all this out. And sometimes they're pretty ugly, situations. The executor reports to the court and to the beneficiaries, the heirs, the distribution, the accounting, full accounting and distribution of the assets. And again, this is not a small job. Sometimes the first thing that the executor will do, change the locks in the house. Oh, Susie's in the house taking the silver. Well, Mom always told me that I was going to get the silver. Oh, really? Well, let's check the will and see if that's the case. So sometimes this stuff gets, a little difficult. So I'll hold out my mother, age 91, as kind of a role model in this case. 5 kids. She was widowed at 39. I was the oldest, 15. My youngest sister was 2. So she's been a widow for 52 years. And miraculously raised 5 kids, put us all through college, got us married. I still don't know how she did this. And has maintained her sanity, which is nothing short of miraculous, and has managed her own finances. She does have a financial advisor, but she's handled all this. Now, why do I hold her up as an example? Nothing gets past Mom. She is named an executor and a co-executor, and I'm thrilled that I am neither. My sister and brother were named, and they will do a brilliant job. It's not my long suit, and one of them lives close to her, and the other worked in financial services, so they are well equipped to handle this. So I'm delighted about that. She's given all of us copies of her will. She's given all of us what I'll refer to as a document locator, where her assets are, and that's the 5th element of a good estate plan. Where are her life insurance policies, bank accounts, brokerage accounts? I mean, I live in New Jersey. She lives in Pennsylvania. I have no clue where this stuff is. But I've got the document locator, so when the time comes, we can find it, which sometimes people refer to as the treasure hunt. Gee, I know Dad had a couple of bank accounts. I can only find one, and I wonder, well, there's only 100 banks within X miles of it. It's hopeless if you don't have a document locator. So a really important part of the process here. Now, one of the cons of probate, it takes time, and there are typically fees, as noted on the slide here. So in some cases, you'll want to title your assets differently to keep it out of probate, and that's one of the tools that your licensed attorney can suggest to you if that's one of your goals. How can we streamline this process and make it less costly and more straightforward and less time consuming? That's an option that you may have. Owning assets jointly, creating trusts, naming beneficiaries. These are some of the tools that an attorney will use. So again, I think there's enormous value in having a licensed attorney do this. And it's not going to be free. It's going to be a few $100, could even be a couple $1,000, depending on the extent and nature of your estate and your goals. It may be straightforward. It may be a little less than straightforward, but no wiser money spent, in my view. Naming guardians, and there are actually a couple of ways you can do this: a financial guardian and a guardian who would, raise your children in a nurturing home, equipping them with values that you're comfortable with. But these individuals may not be the best managers of money, so you may also name a financial guardian to oversee the finances on that minor child or children's behalf. So a lot of choices here. The executor, I talked a lot about that earlier. There's a lot of responsibility here. It's a significant time commitment. You want to be sure that that individual is equipped and willing to do this on your behalf. And these are even a listing that goes beyond what I said before. So when your will is prepared, you want to have it in a safe place. But if you're like my mom, she's got it in a safe place, but she also gave us copies. So there's no confusion. Who gets what who does what, where is it. Um, you know, she even went to her church. I was so grateful. She told me a few years ago, yeah, John, I went and talked to Father Frank, and he has the whole service and my wishes in his file. Well, I am thrilled, because that way there's no guesswork. What kind of service does Mom want? She planned it. She went and met with the Episcopal rector, and it's done. It's on file, and that's a great thing. So there's no substitute, in my view, for being totally thorough here. So making copies, reviewing periodically, everything I've mentioned is noted on this slide. Now, my goal here is not to make you an expert on trusts, but just to kind of make you aware of that no matter what you want to do with your money after you're gone, there is probably a way to direct all or a portion of your estate utilizing one or more trusts. There's a lot of flexibility here. But again, you need a professional to guide you through this. We're back to, once again, reason number 23. I've been counting 23 reasons why you want to use the licensed attorney in your state. So you, the grantor, are naming a trustee and naming beneficiaries, and the corpus of the trust, if you will, is the direction. Under what circumstances are these assets going to be distributed, how and to whom? Now, trusts take different forms. I just want to be clear that when you use the word irrevocable, today at age 67, this may seem like a good idea to me. Is it an equally good idea at age 87? Well, I hope so, because I can't change it. Irrevocable means you cannot change it. Now, typically, you get more tax goodies for irrevocable provisions, but you have to balance that with, is this something that I would never change my mind about? So you just want to be clear about that distinction. Medical treatment, I've referenced this. Let's get into it. Durable power of attorney. This is for managing your finances. If the main person that manages finances becomes incapacitated, there should be somebody legally named. By the way, if this is not done, you will go through, this is a technical term, living hell unwound with your bank, with credit card companies, medical authorities, getting bills paid. If that person is incapacitated and no one is named legally, it's a really difficult process to unwind this. So once again, underscoring the importance of all elements. Let's just name them to be clear. Will, general durable power of attorney. That's what we're talking about now for managing financial affairs. Healthcare proxy, okay? Living will, number 4. And number 5, I referenced the document locator. I call it the roadmap to your treasure. If you got all 5 of those things clear and legally enforceable in your state, there's a high likelihood of minimizing drama, and nobody likes drama, particularly in managing an estate. So here we are with a living will and healthcare power of attorney. So healthcare proxy, healthcare power of attorney, those are synonyms. Living will, and you really need both. Living will typically has, for some people that choose it, a do not resuscitate order. So if you are gravely ill, the DNR will let you pass naturally without extraordinary means taken to prolong your life. Some people don't want that. Obviously, very personal decision. Healthcare power of attorney, bottom paragraph here. If you're incapacitated, as I mentioned earlier, allows someone else to make medical decisions on your behalf. And if you don't have this, it really gets ugly. State regulations, hospital regulations, doctors' codes of conduct, it really gets dicey fast. I know about 10 years ago, my mom got pretty sick. I went and talked to the doctor. He said, wait a minute, I can't even have a conversation about this until you show me the healthcare power of attorney, healthcare proxy. He had one, but it didn't cover me. It turns out my sister had to have that conversation. But thank heavens, there was one in place and a family member that had that conversation. So really, again, an important element of that estate plan. So letter of instruction, this is often overlooked. And it's really key. I reference my mom's wishes for her service. I mean, that's outlined, it's in writing, it's part of her packet in the letter of instruction. It's also on file with the church where she wants to have her service. There's no substitute for thoroughness here. So, specific things. I mean, my mom has actually been working at this for a number of years. I really give her a lot of credit. If I do half as good a job as she does, I'll be lucky. But she inventoried all her stuff and actually put little notes underneath major items. This is where it came from. This is who I wanted to go to. And she's always said, if you want something, tell me now so that I can, like my sister Wonder Dining Room said, I mean, that's great. It's going to somebody who truly wants it rather than somebody taking it. Oh, it's mom's. It's a family thing. I guess I should take it. Displacing, something else. So again, I think being open, being transparent, fostering communication, those are key elements in a successful estate plan. Keeping it current. I mentioned if you're moving, you always want to get it updated. This is the document locator that I've talked about and referenced several times. Where are all these, assets, certain key, pieces of paper, IDs, and so forth. And don't leave out, not really important in my mom's case. She's not a big social media person, but, passwords and stuff for, social media. What happens to this stuff after a person dies? I mean, you want to think about that and empower someone to, manage those assets. Well, close them out, keep them up, whatever the person's wish is. So estate planning documents, here they are. The 5 items that I've mentioned several times. So you want to have these, updated. And once a person dies, then some of the other elements that we've talked about, beneficiary designations, which drives the distribution of certain assets, letter of instruction, will for personal property. This is a nice way to put everything together. Yeah, I need all this stuff, but what does it do? I think this slide really points that out. All right, so managing gifts, another opportunity some of you may want to take advantage of. It's been raised. It's now $16,000 per year per participant. Couples can gift up to $32,000 without generating a tax liability for the individual or the gifting person. It actually can be extended beyond that up to the lifetime gift exclusion of $12 million. Now, I don't have to worry about that. My estate is barely a glimpse of a shadow of $12 million. But this is at the federal level once again. We've got a very high limit here. So reducing taxes through gifts, this is something a lot of people don't realize. And actually my mom, who again gets an A+ in all this, she's on top of stuff that I was barely thinking about until recently. She has gifted over the years to her kids, grandkids, and now great-grandkids. And that gives her a lot of joy to help kids get through school, to address things that may have arisen in people's lives. So if she gives, pick a number, $10,000 to somebody, over time, typically the value of that gift will grow. So in fact, the impact to her estate is actually larger than $10,000. So gifting really can be a good thing. She's very generous with charities as well. So again, that can really help at the end of the day mitigate the size of any tax that might be due, particularly at the state level. So finally, minimizing estate taxes. We'll talk about state and federal at this point. Gross estate, we talked about everything being in the gross estate, and this diagram really helps you see the process here. What's the executor doing? Compiling what's in the estate, discharging any obligations, liabilities, debts, etc., and then subtracting marital and charitable bequests, and then you've got a taxable estate. And typically, that's what's subject to tax at the state level, depending on how the state works. And this is kind of a nice example of 2 individuals. And the whole concept here is There's a joint component and an individual component, and I think this chart really looks at it. So they both have savings plans, they have IRAs, and they've got joint assets as well. And when you go through the math, how is the joint divided up? Well, 50-50, and you add that to the individuals. So the numbers are nice, neat, and tidy here, and it shows how individual and joint accounts are accounted for from an estate planning point of view. So I think kind of a helpful exercise here. So what about federal estate tax? Well, as I said, it's going to be, actually, I guess this sunsets later than I thought. I was thinking it was 2024, but it looks like it's even further. So that's good news. We've got a few more years left with the current estate planning legislation not expiring. Who knows what will happen in the future. But today, it's roughly $12 million and continues to go up for inflation. But actually, okay, here's what happens. 2026, look what happens. Wasn't off by far. Goes to $5 million. That's a big difference. Okay, so unless it's changed, the current 12 could go to 5 when this thing sunsets in 2025. So I was off by a year here. So something just to be aware of. This is not the be-all and end-all forever. Estate tax legislation can change over time, so you want to stay current, obviously, through updates with your professional. So we've talked about some of the tools to reduce estate tax, gifting, direct payments, charitable deductions, the marital deduction, basically the I love you will, the unlimited deductions that says everything goes to my spouse, unified credit, that's the federal exemption, $12 million per person. So for a married couple with the proper filings, it can be over $24 million, which is really key, obviously. Life insurance, this is something you want to be sure you have adequate life insurance, part of the estate planning process. And the folks on the Navigate Planner line can help you with that. They'll ask you a battery of questions. They have an instrument that can ensure if I die, how much life insurance should I have so that my loved ones can continue in the lifestyle in which they've been accustomed. And if my spouse were to die, the same thing. So finding the right attorney, I think, is key. Networking, Better Business Bureau is a good way to do that. Speak with friends, but you want to have a licensed attorney in the state in which you reside. That's really the key. This has to be updated periodically. I've talked about moving, law changes. We just referenced that. Periodically, not a bad idea. The good news is reviews are a lot less time-consuming and expensive versus putting one together for the first time. So keep it current. So as usual, the folks on the EY Navigate Planner line, I mentioned the planning meeting. That'd be the first thing I do, is have a conversation with them to equip you to prepare adequately, for that meeting. These are some of those things that they can help you with. So once again, this resource, unlimited to you, never a charge. You really want to take advantage of it. And once again, the action plan list. Hopefully you've jotted down a few things that will be relevant for you. This list may give you a couple of other ideas. And finally, once again, we deeply appreciate your taking just a couple of minutes to give us feedback on the presentation here, the content and presentation. And the workshop ID, when you log on, you're going to need for estate planning is 41161. So please jot that down, 41161. Let me just take a moment and give you all four for each of the four, just to be sure you have them. For Social Security and your retirement, our first session today, 41159. Second session prior to lunch, 41160, dissolve that debt, 41160. And we completed Achieving Financial Wellness after lunch, 40998. And what we just finished, estate planning, 41161. So with that, I'll just open it to Bob, see if there are any questions that I might address.
Hey, John, really great information. We had a couple of questions, a couple of comments. I think the participants were very engaged. Someone commented that they really, really liked the idea of the labels or labeling things or giving away things to people that express interest or leaving things behind. They just thought that was really practical and neat. Another person asked, they have elderly parents and they have a power of attorney, which is a great step to help manage their assets. And they have the original from the lawyer, but the person indicated that their parent has like 16 different bank accounts and financial institutions, and they're wondering, do they need to present an original of that power of attorney, or do most institutions accept photocopies?
Wow, great question. My guess is, one, I don't know the exact answer. Navigate Planner Line could answer that. My guess is the different institutions have different practices. That's what I've seen. Some would take copies, some would not. So I think for this individual, this sounds like a pretty complex situation. A couple of suggestions. Number one, make sure the financial power of attorney, I think that's what you're referencing here, bank accounts, et cetera. Make sure it's up to date. Make sure it was prepared in the state in which that parent resides now. So make sure it's current. And then step two, I would basically, contact the institutions, because if half of them need an original, then you've got a task to come up with more originals. But great question. My sense is a little bit time consuming. I think that's an institution decision. That would be my guess, but confirm that.
Yeah, let's hope these institutions have some flexibility with that. I would think a photocopy of that document would be fine, but let's be sure. Someone had asked,
Right.
You got them thinking, John, about beneficiary designations, and it's something we always mention at seminars and webinars for your Wespath accounts. Even during your active ministry as well as in retirement, maintain those beneficiary designations. They're not elections for your defined benefit plans, but for your account balances, they certainly are. How do you do that? Go to Benefit Access, manage beneficiaries, and update it. Often they'll have the spouse correct. I've seen a lot of times they'll have children as contingent or secondary beneficiaries. Children have a tendency to move. Update those addresses as well would make that really helpful. Question just came in right under the wire, John. Will we have access to Wespath and EY after retirement, correct? Question mark. Well, yes and no. Definitely Wespath. We have a relationship with our retirees. That's a big part of our 100,000 participants are retirees and surviving spouses of those retirees. If you maintain a balance of $10,000 in Wespath administered accounts, you will still have access to EY financial planning services. You'll always still have access to EY to call our participant solutions area, talk to a benefit educator, but EY does require maintenance of a balance with us. That was all the questions that came up. I want to thank you all for participating in this series of 4 EY workshops. John, I know it's a long day. I look forward to seeing you down the road. Keep up the great work. Keep chopping that wood back there, John. You got plenty of years to go.
Yeah. Okay, great. Well, thank you, everyone. The questions were great. I hope the sessions were informative. Best of luck to everyone. Use your resources and have a great rest of the day.
Hey, thanks, John. Take care, everyone. And on behalf of the Baltimore-Washington Annual Conference, great to see you all last week, and thank you for putting this together. Take care.